When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. OBASEKI Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020-7739-7549 or go online at www.legalpal.com. When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. OBASEKI Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020-7739-7549 or go online at www.legalpal.com. When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. OBASEKI Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020-7739-7549 or go online at www.legalpal.com.
A very good evening to you, and thanks for joining us tonight on another episode of your lovely program, Truth and Justice with Dr. Jennifer OBASEKI. How's your day been? Well, it's really, really hot. Gosh,
Hot.
I hope. How's your day been, Jenny?
Hot. Hot and lovely.
Hot and lovely. Please drink lots of water, isn't it?
Yes, keep yourself hydrated.
You need to stay alive. Thanks for joining us again tonight. Thank you so much for those who got in touch with us after last week's episodes and those who call in live.
Yes.
The studio line will be open today, especially that we are discussing a very serious issue. To some people, that word is so scary. Immigration. Some people don't want to hear that word, immigration, at all. It's a very scary word. Well, today, Dr. Jennifer will be taking us through the nitty-gritty of immigration and why you should really not be scared, you know.
Not at all.
Not at all, you shouldn't be. So please call as many as you know will benefit from tonight's
Share
episode.
the page. You can like our page, Truth and Justice TV. We have a page on Facebook now.
Yeah.
So please like us, follow us, but most importantly, tell us your stories.
Exactly.
Let us know how we can help you, because that's what we want to do. It's all about bringing your cases to the forefront, because often our situations in our community, our cases, our issues are not always brought to the forefront. So we want to do that for you.
Exactly.
So your questions on visa applications, changing status, all of the above, let us know so we can answer them for you today.
Exactly. So tonight, call your friends, family members, anyone you know would benefit from this topic tonight. Immigration. We'll be looking at visas, routes to, you know,
getting settlements,
you know, you wanna, you know, it's gonna benefit you seriously. So come on, call everyone who needs to be part of tonight's episode, and let's, have a great show tonight together. Our studio line will be opened. We'll take as many calls
as we can
before the end of the show tonight. And don't forget, you can email us your questions. You can drop us your comments and questions on Facebook as well. We'll pick them up live. You can call into the studio live. You can call into our mobile live here. We are here to serve you. So come on, reach out to us tonight. We'll go on a short break, and when we return, we'll kick the ball rolling on this topic tonight: immigration. Don't touch that dial.
When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. OBASEKI Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020-7739-7549 or go online at www.legalpal.com.
Thanks for staying with us. Tonight, like I said, we'll be dealing with this serious topic, immigration. Dr. Jennifer, why is immigration a scary word, and how will you better explain the concept of immigration?
Well, first of all, it's because it involves people's lives. It involves where we're going to be established, where we're going to live, how we can go and visit family members. So it is so pertinent to our very existence. And we're in a global community. We are moving around the world. In order to prosper, people are moving to different pastures, new and green, to study, to establish themselves. And as we know, immigration has become a bit of a political football. It has become a dirty word as a result of some political parties. We've seen the growth of the far right in Europe. We've seen the growth of UKIP. We even saw how immigration forced the UK government over the issue of Brexit. So immigration is a very serious issue. And on top of that, unfortunately, we've seen the rise in hate crime towards migrants. And following Brexit, we saw the increase on attacks, more than 20%. And that's a very serious thing. So as a migrant, unfortunately, some people see that as completely negative. During that time, I started a hashtag which was migrants mean business, because most people migrate to bring positive to a community, or to bring positive things like culture, their work skills, their workforce, their spending power. But again, it just became such a dirty word. But when you see a country like the United Kingdom that has so many fingerprints, historical fingerprints, through its history through the Commonwealth, its history through trade and other links, there are definitely so many people here that have the right to invite their friends and family to come and visit them. And when it comes down to the rights of family members, those are enshrined in the Human Rights Act. Those are also enshrined in legislation within the UK immigration law. So it's important that we give you a step-by-step talk through some of your situations, or let me say examples of what should be done in the right way to make sure that you can try and achieve immigration success. If I put it that way.
Yeah, I think that better explains the concept of immigration. Now let's move down to visas and how to apply, extend, or even switch. So what are the categories of
now
applications you would
when you
say?
want to come into the United Kingdom, or you're here and suddenly you have a letter from family members who want to come and see you. They want to come and visit, they want to come and study. So normally you have those two particular criterias: ordinary visitor, family visitor, student. And last week we spoke about business visitors as well. So you can think about the purpose, if we can say it that way.
Why do you want to come over?
Why does that person want to come into the United Kingdom? All of these things we're discussing are so important, especially because, as we keep saying, Brexit is around the corner. You know, it's less than, I think someone said it's less than 200 days or something like that. So, I mean, it's just March.
Yeah.
So, first of all, if you're a European national and you're residing here and you haven't had family come to visit you, or you haven't had dependent members who you can prove who you are sustaining in the home countries to come and visit you or come and settle, you need to get your skates on. So the first people, because they're time pressured at the moment, I'll talk about, is European national.
Okay.
So you're an EA national, you're living, you're working, you're studying, or you're disabled and you're living in the United Kingdom. You have family members who you are in contact with, who you have a relationship with, and who you are sustaining. So you're sending money to them. They're dependent on you. And that word dependent can be financial, also can be emotional. So those people, if they've not come to the UK, number one, you don't want them to come and settle, then you should be applying for them to have a visitor's visa. It will help them on their immigration footprint. You can ask for them to have a multiple visit visa. And that's good, because it shows the Home Office that they intend to come and go back. And establishing or proving that you intend to return is often the biggest problem. So they should be engaged in their country of origin, have a clear footprint. So that's they're established, paying their tax in school or working. Then if the EA national actually wants them to come and settle, showing that level of dependency is actually crucial. So you must show that they have been financially dependent on you or emotionally. So that's showing family link and then also showing dependence, essential. But moving on to UK residents.
I was gonna ask
we
you
move
questions
on
on that.
to UK residents. The one thing that we look at is, one, the person who is in the UK, what is their status? We spoke about EU nationals now. If you're here and you only have temporary status, there may be an issue. The Home Office is going to look at how are you going to support the person that's coming, whether they're coming permanently, do you have space for them? If they're coming temporarily, can you show that there's enough funds to support them? So if they themselves, the person that's coming, has funds, then that's even better. They can show by hotel receipts, bank statements, showing that they can sustain themselves, which is not an issue. But you that's inviting them must show a level of permanent status. So if you've got only temporary leave to remain, it's not a big issue, but you must be able to show that, one, you can support the person that's coming in, or the person can support themselves. Secondly, if you have indefinite leave to remain, much more of a permanent status. So a lot easier for you to show that you are a resident here and you're permanently resident here, and that you can sustain the person or support the person that's coming, showing your bank statements, your income, your proof of accommodation. So that is your tenancy agreement or confirmation that you own your property. And then also going that step further to show that you're going to help the person that's coming comply with the requirements to go back. And if you're British, that might entitle you to allow someone to come in and be settled with you. So again, if it's a child or a dependent adult, you have to be a little bit careful, because two things people are not aware of. People who are over the age of 65 that want to show that the UK national is the sole person responsible for their welfare. And this happens, as you know, as our parents get older, our relatives get older, they may want to come to the UK, and before you know it, there's really nobody in Nigeria or Sierra Leone or South America where they've come from to look after them and really look after their welfare properly. You have to show really that you're the only person in the world. So if you're from a sibling group, you have to show why you are the best placed person or the only placed person that can cater for that person's welfare. Be warned, very few of those applications are allowed in the UK. So if you're going to do it well.
Do it well.
Yeah.
Don't.
Not mediocre.
People don't want to pay lawyers.
I know, but it can't be mediocre. And because if these applications are refused, not all of them have rights of appeal. Be warned. So it's not that you can then, suddenly appeal to a judge. Some of them you can ask for a review by the embassy within so many days, or usually within 14 days. You can apply for an administrative review. That's not a right of appeal. But if you feel that you should have a right of appeal, then you can argue why it should be granted to you. And then If the review comes out and it's not successful and there's no legal right of appeal, you can apply for judicial review. That is going to the High Court and asking a High Court judge to look at the reasonableness and the fairness in consideration of your evidence by the entry clearance officer. They do get things wrong. If you feel that the decision's wrong and unfair, get a lawyer to look at it for you.
Absolutely. That's a good one. Thank you so much. Now let's talk about someone who is here, probably on a student visa. The man is here, wife and kids are home, and he couldn't just cope without his family around him. What's the provision available for this kind of
Well, you see, students can apply
partner or
for
spouse visa?
yes,
they call it?
dependents to come through and stay with them in the UK on their student visas, but the financial requirements showing that you can enable and support your dependents is the key thing. Because when people are coming into the UK temporarily, you must show that you're not going to have any recourse to public funds. And that means basically you're not going to be reliant on the state for benefits, for support, or for resources in any shape or form. So the financial requirements as to a spouse and then having dependent children, it grows with the number of people that are coming in with you, basically. So you must, apart from showing that you can afford the fees, and then if you're living in London, there's a higher allowance with regards to accommodation costs.
Absolutely.
Holding these funds again in your bank account for more than 3 months before the application, then showing that you've got the additional funding requirement for spouse and dependents is key. If you're not sure, don't guess, get help.
If you're not sure, don't get
Don't.
get help. Get help. Okay. Someone who is here has got kid from a British partner, but hasn't got any status. What's the route they can
Now
take
you
to
see,
to
the Home Office has started to see a massive wave in applications of people, single women, who are claiming for basically parental leave
yeah.
through the parental route, settlement through the parental route. And why has this happened? Because it's happened because any child that is born in the UK to a British national or to somebody who has indefinite leave to remain, or even an EU national who's been working in the UK continuously for more than 3 years, once that child is born to a parent who has one of those situations, then the child can actually claim a British passport immediately upon birth. Now, something that happened last year, towards the end of last year, is the Home Office retained a discretionary right to refuse such applications. Though it says on paper, yes, you have the right, and also the same with naturalisation, it actually, one word changed. So rather than saying will, it changed to may. That will and may are two different words.
Absolutely.
So it allowed the Home Office to retain the right of discretion. And discretion is really about, I can give you this thing, but I need to see that you qualify for it. Or, but let me even have the right to ask you questions before I give it to you. So the right to ask questions now enabled the Secretary of State to infer or request that people provide blood tests.
Yeah.
DNA
test. Yeah.
that they are the biological parent to the child. So if you are a person who doesn't have papers and you want to register yourself through the parental route because you've given birth for somebody, the other parent is British, has indefinite leave to remain, or is an EA national that's been working, exercising treaty rights and has their residence card here for more than 3 years, then you can make that application once the child is present and has the birth certificate. You can't do it before the child is born. Some people are making that mistake. And then once the child is born, much easier to do it once the child has the British passport. Why? Because that way the child has confirmed their status. If you go with just the birth certificate, that's when you might get these wavering requests. Passports can be done in a day. Passports can be done by express. You just call the passport office, book the appointment, and it can be done within a couple of days on appointment. In any event, can be done usually about 2 weeks. The passport application process in the UK is quite secure, can be done at the post office, and so it's better to do such applications when you have the British passport in hand.
Yeah.
And then the application itself,
Yeah.
if you don't have status and you're suffering hardship or you're vulnerable, then you can apply for a fee waiver if you can prove a level of destitution, or you can prove that your income does not meet your outgoings and is very low. So you have to prove the level of vulnerability. Okay,
Well,
so we have a first call today.
Let's take that call.
Let's take the call.
Hello, good evening. Thanks for calling us tonight.
Good evening.
Good evening.
How can we help?
Yeah, I just want to very brief question.
Yes.
Go on, please.
Okay. If someone, right?
Yeah.
If someone has been in the country for like 6 years,
Mm-hmm.
and he came with a visiting visa,
Yeah.
which has expired long time now,
Okay.
and then he now got married, right, in the country about 4 years back. To someone that has a leave to remain through refugees, right?
Yeah.
And so it's still been denied up to last year. He almost been taken back home. Then, anyway, he now declared asylum. But altogether, let's just cut the long story short. Still struggling with them, finding and all that. I mean, what do you think, ma'am?
Do they have children?
Yeah.
They have children together or stepchildren?
No, not yet. Not
Step-
yet. Not
step-
So
yet.
no
children.
children.
Yeah.
All right. Such an application is very difficult, even when you're married. The reason being is that the Home Office feels that you'll jump in the queue when you make an in-country application of sorts. If the person that has sought asylum is not from the same country as the person who is the overstayer, the Home Office will expect you to go to the country of the overstayer and apply for entry clearance to come back in. Not necessarily both of you, but they will expect the person that's overstayed. So it's difficult. You have to prove, number one, that you're in a relationship of more than 2 years. Then at the same time, unless you can show that there's some exceptional circumstance, then they will see there's no reason for you not to go back to your country of origin and come in. Now, the fact that they've been married for quite a long time, 4 years, as you say, it's okay, but it's not something that's going to sway the Home Office.
Yeah.
Only exceptional circumstances or a child would sway the Home Office. So thank you for your
Are
question.
there children involved in your relationship
No, you
at
said
all,
no.
even if it's not?
Even if there were stepchildren, it would then add additional onus
Exactly.
for consideration on the Home Office. When there are children involved, the Home Office has to consider the welfare of the child.
Exactly.
Many people overlook that. And where there's stepchildren, even if they're over a certain age, the emotional bond between themselves and the biological parent, the inability for them to maintain a relationship with you if you're going to be removed from the country, all have to be shown. And if there's ill health, additional dependency or vulnerability as a result of special educational needs, all of this is best presented in an expert report by a social service worker, or that's a social worker, or an educational welfare officer, or a psychologist, really. So if there are special circumstances, it may mean you meet the exceptional circumstance test. So do make sure your evidence is prepared and submitted expertly, as best as it can be. Don't just wishy-washy put in an application.
No.
The fees are too high to mess around. It's best done properly.
Okay. I was going to ask you before the call came in that if someone applied as a parent of a British or citizen child and such application is refused, is there a right of appeal? What would they do differently?
You
before
can't.
the submissions, or what's
You know, the
way
thing
forward?
with the appeals, and we have to be very clear, appeals are not automatically bestowed. You have to show that there's going to be a breach of your human rights, or the right of appeal has to be enshrined within the application process, within that criteria. And often when people engage in relationships, like here we heard that they've been together for over 4 years, married, but unless you can show that there's going to be a breach of your human rights when the application, if is refused, may not automatically have a right of appeal attached to it. You may have to argue that by showing the fact that human rights are engaged. And human rights, the right to life, the right to prevention from degrading treatment, the right to family, the right to be free from discrimination, all of these things can be shown on the facts. It's not just picking it and plucking it and writing it on the grounds of appeal. You actually have to show evidence of these breaches. And then at the same time, if there's an error by the caseworker in assessing the case. Now, do you know that Home Office caseworkers, after they make a decision, it actually has to be signed off by another caseworker? So if you've got an immigration officer caseworker who's assessing your case, wants to grant your application out of sympathy, they know that somebody higher is going to check that decision and cannot allow just an emotionally charged, let me say, decision be passed. You have to give the immigration officer, the caseworker, the tools that they need to grant your application. Remember that. English law is about show and tell.
Show and tell.
Not just tell.
Absolutely. I like that description. Show and tell.
You have to have the evidence to show as well as tell by making the submissions. Exactly.
Interesting. So can children apply as well?
Of course. Now, what we see, and as experts in child law and immigration, we do have a lot of young people, children, coming to us either through social services or directly, and then bringing their guardians along for us to give them help and advice. And children can actually instruct solicitors alone with the support of their guardians. And you see, they can apply independently, and it's also good for children to apply if they're in a unique position. Once upon a time, once a child hit the age of 5, it was a magic number. And from the child getting their leave to remain to the parents, to other family members, was the situation. But that all changed in 2012. Okay, so now you've got the age of 7, and initially 7 was the golden rule, but then the Home Office saw the actual tsunami of applications. I thought, hold on a minute, if these children are supposed to be going back with their parents, then they should be going back with their parents. So what you have to show is that once the child hits the age of 7 or has spent 7 years in the UK without leaving, if they're to be removed, they're going to be insurmountable barriers to them reinstating themselves in their home country. Then they can apply. And people say, what are insurmountable barriers? It's not just my child does not eat eba, or my child does not eat African food or South American food, or cannot stand the hot weather. It really is evidence to show that the child has significant needs that will prevent them from establishing themselves or settling in their home country.
Language could be a barrier as well.
Language is a barrier, but on its own it's not if you've got the parents to support. And you know, even though Nigeria's official language is actually not English, but we speak it all over the country, it's not seen as a barrier for the child not to speak their native language. It has to be things like ill health, education, educational needs. When I say that, so if a child suffers with something like autism, or is blind, or has deafness, then those, if there's no provision in the home country that will ensure that the child is well established, or that might cause risk of harm to the child, then you can then try to argue the case. Most of these cases, though, just on the 7 years, are no longer being granted. Be very clear, you must show clear proof of insurmountable obstacles to settlement. So many people are kind of laying low to the age of 10. And then when a child is entitled to naturalise as a British citizen, that's when the child is being presented to the Home Office.
And would that apply to a child whose parents has got no status?
Yes, indeed. So it's all about the needs and interests and what is best regarding the welfare of the child. You know, a child's formidable and formatting years, when they're establishing their personality, they're very sensitive. So if you take a child out of an environment and move them into something completely unusual and different, it can affect their building as a person. It can affect their personality. It can affect them psychologically. So this is why it's quite noted around the world that when you look at the interests of a child, you must ensure that their welfare and reduction of any risks to them is paramount. So the only problem that we have in the UK at the moment is the astronomical fees. So you can imagine if a family is waiting for a child to reach the age of 10, manages to get to the age of 10, then they find themselves going around really asking for money because it's over £1,000. And that's for a child, which we think is quite unfair. And we've joined many groups to try and make sure that the government actually reduces this. And if you're interested,
our campaign is still on.
Our campaign is still on. You can join us. That's with Affirm Human Rights. There's also other groups, Migrants for Justice, all trying to campaign for this. Now we're going to be going back to the House of Commons for the third installation, and that's going to be on the 12th of September at 6 p.m. So if you want to register yourself, have your say, give your response to the government, it's going to be on the 12th of September at the House of Commons.
You can check our page.
Check the Truth and Justice webpage. Truth and Justice TV. Try to register through the Eventbrite link, and also like our page and start following us.
Interesting. So if you want to, come to attend that event, ask your questions live, get help that you actually need. Share your story. There will be experts there on ground.
We've had judges on panel, we've had MPs on panel. So it's very, very crucial that if you're feeling the hostile environment, it's important that we don't just talk about it, that we offer the government solutions. We offer the government alternatives to the hostile environment and give the public's voice direct to the MPs so that they're fully aware of what changes are needed in the community.
Before we go on a short break, I want us to clarify this. Some people don't know their rights when it comes to a child is 10. They think because they have no status, their child hasn't got any rights to do anything. So if a child born of parents that have no status in the UK is 10, what is the process they have to go through towards naturalizing such a child? And can the parents now depend on that child to get their own status?
Right. First of all, there's what's called the Form T. You have to apply to make sure the child is basically entitled to get the status. It's not exactly the same as the naturalization form, so be aware there's your naturalization form and then there's the minor form, registration form. So what you're asking for is for the child to be registered as a British citizen. So after the child is accepted to be registered, then the child will directly be able to apply for the British passport. Once the Home Office grants the application, there's two things that will happen. Number one, they normally give you a certificate, and that certificate you can then take and do your naturalization ceremony if you're over the age of 18, but if not, you can then just apply for the British passport.
Okay, let's quickly take this call. Good evening, thanks for calling.
Good evening.
All right. Well, basically, I'm on the telly and I saw this and I don't understand what it means.
Well, we'll explain to you. All it is, it's about advising people about their immigration status. Truth and Justice TV.
Another call.
Another
good
call,
evening,
please.
thanks for calling.
Good evening, thanks for calling.
Hello, good evening. Hello.
Good evening.
Hello.
Hello?
Yeah, can we help you?
Right, basically, I lost Jesus.
Oh dear, I think we have a prankster on the
Okay,
call.
I guess.
So, going on to your question.
It's good to love Jesus, yeah?
Yes, it's very good
Keep
to love
loving Jesus.
Keep loving Jesus. But going on to your question,
Yes.
the parents, once the child has the British passport, what happens next is the parents then can apply through the parental route.
Yeah.
However, you see, when it comes down to the parental route, what the government looks at is who is caring for the child, and if the child has contact with both parents, the relationship, and then they make their decision. So again, it's not completely automatic.
Okay.
It has to be the person who has the care that the child resides with. And at the same time, if both parents are living together, usually the application is granted because the family is not expected to separate. The Home Office cannot be seen to be separating families unless one person's presence is not conducive for the public good. There are legal tests across all of these areas. So if it's one parent and the child is living with one person residing with one person and not the other, then the person who the child resides with usually has a better chance. The other parent just has to show a level of relationship. So that could be regular contact, and it has to be positive. So if the parent is, for example, incarcerated in detention and the child is not seeing that other person and that parent doesn't have leave to remain, can be difficult. But if both parents have regular contact with the child resides with both, then the application should be fine. We do have a lot of issues with our clients that are in detention. We do not forget about you. Things can be argued positively in your favour. So do make sure that you try to keep regular contact with family members, because that becomes quite crucial at appeal hearings.
Exactly. Okay. I would please ask that those who are not ready to call and ask questions relating to what we're discussing here today should please not engage the line, so that those who actually need help can come across. Please. We'll go on a short break, and when we return, we'll keep having a chat with you tonight on our topic, immigration. You have any questions? Give us a shout. Don't touch the dial.
When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. OBASEKI Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020-7739-7549 or go online at www.legalpal.com.
Thanks for staying with us on your lovely program, Truth and Justice. We've been talking about immigration, and like I said, the studio line is open. If you need us to answer any question for you tonight, do not hesitate to call the studio live. We would, attend to your questions. Okay.
Also, please don't forget you can email. If you're a shy person, please email esther@obasekisolicitors.com. So esther@obasekisolicitors.com or info@obasekisolicitors.com. I know that many of you may have sensitive topics or sensitive issues you might not want to discuss on air, and because of confidentiality, if it's something that's quite extensive or you have documents you want us to look at, email us, please. Let us help you.
We will definitely love to help. Let's talk about this serious one, private life. Application on the basis of private life. What would you say about this?
I'd say to you, be careful. Many lawyers are out there and they will tell you, oh, you can do a human rights application, or you can do it based on your private life. And as I say, these things have legal tests. You can't just write to the Home Office and say, I want to stay based on my private life. I've been here and established a private life. No. Private life is something that is established over a duration. And if you've considered to be, I've been here only 6 years, like our example given earlier, or 10 years, but you're in your 30s, it shows that you've spent 20 years out of the country. And it shows that you've had most of your private life out of the country. Even if you want to consider your formative or your adult years, the government's going to look at, one, your capability to re-establish yourself in your country of origin. It's also going to look at your resources. If all of your family is back in your country of origin, that's where most of your family life is. Your private and family life is, again, one of the human rights that's enshrined under Article 8 of the European Convention of Human Rights. But yes, generally worldwide, everybody is expected to have protections for their rights to life, establishment, movement, but this is all within a country's own right to protect its borders. So the country we're in, the UK, has a right to protect its borders by operating an immigration policy. So whether you've been here, you've established yourself for 6 years, 10 years, but you're here unlawfully, then the UK government has a right to protect its borders by asking you to leave. Or for you to exercise your right to make an application, and if the application is not successful, for you to exhaust any appeal rights and if those are exhausted, ask you to leave or even help you leave by removing you. So two things. One, if you've been asked to leave, must you leave? You can choose to leave, you can be administratively removed, you may even be deported.
So what's the consequences of those three choices?
The consequences of those are, if you leave administratively, if you leave voluntarily,
return.
You may be able to apply to come back in. Within a very short time, actually. But if you're removed administratively, there is a barrier on you coming back within almost 2 years. And if you're deported,
10 years.
It's 10 years. So when you're in detention, you've got to have very expert and succinct advice as to which of those options you're going to take. If you are not successful in your bail application, then you have to think, do I leave voluntarily? If you do not have any further rights for submissions or applications or money to make further applications, why would you stay in detention, and why would you put money towards something that's not going to be successful? So you've got to have that succinct, proper advice. It's not just about you being a human being, living here and having family.
I have a right.
The right to family, I know. Many people, and again, lots of lawyers, unfortunately, have taken advantage of people on this topic, telling them I can make a family life application for you, human rights application for you, and it's not exactly as straightforward as that. If any lawyer is going to give you advice, very keen that you highlight these things. Number one, you've got to make sure that they're an expert. That means they've got 3 years or more in the field of practice that they do. Number two, you've got to make sure that they're associated with a professional body. That's the Law Society, the OISC, or the Chartered Institute of Legal Executives. You've got to make sure that they have insurance to deal with your work and your paperwork, because it's sad when you see people coming and say the solicitor has disappeared, closed down, and all their paperwork is gone. That's proof of how long you've been in the country, and you can't easily replace such documents. And showing length of time that you're in the country is very crucial to these applications, because as I've said to you, it's about show and tell. So if you have nothing to show and you're just talking, people may not believe you. So it's very important that your documents are all secure at all times, even when they're with the professional advisor. And then at the same time, you have to make sure that you understand what that lawyer is going to do for you. You must make sure that they give you a letter of engagement, a client care letter, that outlines what they're going to do for you, how long it's going to take, and the cost. So in that letter, that should outline not just human rights. It should tell you on what basis your application is going to be successful. It should also tell you what evidence is needed. If your lawyer, legal advisor is not doing those things for you, they are not the right person for you. They may not be qualified, because if they're qualified, they'll know that they must have those things that I've mentioned. And that's must have those things that I mentioned.
Okay, so that's on private life basis.
Yes.
So how long do you think someone should be in the country for to be able to actually put in a valid
Application.
private life
Very,
application?
very important question, and it's subjective. Objective are things that are out there, the law, the case law, the policy, the procedure, the criteria. But subjective, that's about you and your personal circumstance. That is, how long have you been here? What are your personal factors? Who have you got a relationship with? Is that person dependent on you? And what's the situation in your home country? Are there any risks to you? Will you be able to maintain your relationships with those who are here, even if you are removed? If you cannot, why not? So all of those factors have to be evidenced and put in there.
Okay.
And let me just say that one of the reasons why these applications tend to fail is lack of evidence. People are not more descriptive as they need to be regarding those subjective factors as to why in their personal life they will not be able to maintain relationships, the dependency factors. And I think that's a bit cultural. We don't often talk about our needs, our emotions, and these types of applications actually need to explicitly state those things. So if you can't do it, again, try and get someone to help you. And if you're going to somebody and they're not getting those important factors out of you, maybe you might want to list for the person. Or even recently I spoke to somebody and They didn't have letters from the child's school,
Wow.
but they were saying, "Oh, I'm looking after a child." But the Home Office felt that you didn't evidence this, and not even that if the child was, if you were so involved in that child's life, where's evidence of it? And where's evidence that you're involved in the child's life? You don't just mention, "Oh, I've got children." It has to go into the script. I've got children. I'm responsible for their welfare. I take them to school. I attend parents' evenings.
Even if
etc.,
you're not
etc.
together with the
Even
other
if you're not
partner.
together with the partner, it's showing the degree of
That
the
you're really
relationship.
involved.
And also, if the child is young, why the relationship cannot be maintained through the phone or through Skype. If there are emotional issues, if the child is clingy, if the child has dependency issues. Very important that all these things are mentioned.
Okay. Is long residence the same as private life? That's the best way to
No,
answer
they're
that
not.
question.
That's a simple, they're not.
Okay.
Long
So what's
residence
long residence about?
has now been moved up from 2012 and 14. It's been extended to 20 years. And that's not 19 and a half. That's not 18. It's 20.
20 years. Also, so if you're 20 years in the country, you have the right to apply for settlement. Is that
You
what
have
you're
a
saying?
right to apply for a period of leave to remain. That used to be given indefinite leave, but now we're seeing people just given 2.5 years. And that has repercussions in itself because of the cost of extending.
Application.
So if you feel that it shouldn't have been 2.5 years that you're granted and state your reasons why, again, you have to succinctly state those. But it's very rare for an appeal to be granted where somebody's been granted limited leave to remain as opposed to indefinite leave to remain. But after 20 years in the UK, again,
Evidence.
show and tell. If you're short, if your evidence is short, for example, you can only show up to 14 years, then you've got 6 years that you need to have addressed, either by way of personal statements, testimonies, people that say they know you. But the best thing is objective evidence, and that's evidence from other institutions and third parties, because a lot of the judges feel that people can just give you letters.
Yeah.
But if people give you letters, back it up with how giving statements, then yes, that's credible evidence. Evidence has to be credible, seem to be genuine, not contrived or put together, packaged. So it has to be genuine, credible evidence. And we've seen in the past where certain people have gone to try and make things like statements, make things like bills. Don't do it. You'll end up calling us to represent you in criminal court rather than in immigration matters. Don't get so desperate that you do desperate things. Don't get so desperate that you do wrong things and make your situation worse
Seek help.
than what it is. Seek help. And 9 times out of 10, if you've been in the country for 20 years, there are ways that we can get evidence to confirm how long you've been in the country. So don't get so desperate that you do the wrong thing, please.
Okay. Don't get so desperate that you do the wrong thing. Adults coming to be cared for by a relative. You touched on it briefly the other time. I want us to dwell a bit more on that before we go tonight. Who will fall into that category?
Now, you see, we're in an aging population, not just here in the UK, but also back home. And because of the transient nature of Nigerian people, not just Nigerian people, as I've said, it's a global society we're in now. You're finding lots of elderly relatives back in their countries of origin while their children or extended relatives are in far-flung places around the country. But as pertaining to the United Kingdom, if you have an elderly relative back home that you're sending money to, that you're also directing doctors on their care, that you're trying to maintain their day-to-day decisions on their welfare, then you may need to ask that they come into the UK so that you can continue maintaining those day-to-day decisions on their welfare. It's very hard delegating somebody's care through the phone. And, you know, dealing with doctors, dealing with care assistants, dealing with landlords, dealing with banks. And if that person, that elderly person in their country of origin has no other person to help them, to care for them, then you might want to apply for them to come in as your dependent. But it has implications.
I was going to ask you, what are the requirements on the part of
Now,
the person
the
inviting?
requirements on the part of the person inviting is one, you must be related. Two, it's usually only extended to parents. But if you have, for example, a step parent, a parent who, due to our culture, is considered not your biological parent, but for example, an elderly relative that is seen as a grandma. For example, my kids will call not just not just their grandfather, granddad, but his brothers and his sisters. And that's culture. Anybody who comes from the compound or from the family home is considered the grandma or grandpa, whether it's the biological one or not. And you see, again, that definition as to family member has been addressed recently in immigration law. So culturally, your cultural considerations have to be put in as well. So it might not be your biological relative, but still you must also show the financial ability to look after the person, also show space. The problem that we do have in those requirements is, as I explained earlier, there's also this additional level of testing that not just about the means, the space, the relationship, that you are the best placed person to care for that person. And that, again, is a very subjective analysis. You know, I talked about subjective evidence and objective evidence. So I hope you understand that you would have to have evidence from other members of the family outlining why they cannot look after the person. Some family members may feel uncomfortable about this, but it's important that the government or the assessor understands that this person's married, has 5 children, this person's husband doesn't like so-and-so, or doesn't get on with so-and-so, or this person is just recovered from their divorce and wants time on their own and is not capable, etc., etc. The reasons need to be spelled out, basically. And then once that's done, there's another hurdle. There's the issue of when the person comes into the country, they should not be reliant on public funds. Now, at times there is a gap between the period that the person, that's the elderly person coming in, can touch any form of benefits. So if the whole idea is that the person comes in, stays with you for a bit, then goes into community care home or gets supported living assistance, please, it might end up with you paying some additional cost or paying towards any care that that person's getting. And so you've really got to be honest about your financial situation and your capabilities of looking after the person.
Okay. Wow, our time is gone tonight. You did mention something about the fee the other time. Before we go tonight, is there any provision available for those who can afford to pay in any of these categories, who are here in the UK, want to put in an application to regularize their status, but for whatever reason they are not financially capable? What can they do? Is there anything?
There are a lot of difficulties. Number one of the things I forgot to say was, if the elderly relative has come into the country on holiday, and then when they're here on holiday, realize that they can't go back, maybe the house has burnt down, maybe their carer has left, maybe the landlord has repossessed the home, then that's a change of circumstances. So change of circumstances is a major thing that often affects people in immigration. We're human beings, we change. Then you may make an application in country and state your reasons why, with evidence. And then in relation to the issue of fees, now the visa application fees tend to start from £186. And don't forget, when you're making applications for someone to come and join you in the UK, the application is usually submitted online here in the UK, and it's only when it's being processed that they call for the person to go to the embassy in the country of origin. That's for both visas and also for passports. So if you've got children who, when you were born, you were either had your indefinite leave to remain or you had a British passport and they were born outside of the UK, those children can apply to have British passports and the application done in country. But there is no provision really for waiving of visa fees for those things. However, EEA nationals have a set reduced fee application. People who are coming in on family reunion as a result of asylum should not be paying fees. There's also the ability to make special representations for children who are caught up in difficult situations, either been abandoned, taken home to have lessons learned, but left there and find themselves in a situation they can present to embassies, or you're just stuck, contrived, even if you're a victim of forced marriage or any kind of other awful situation, then representations can be made on your behalf. But in the
Without
UK,
you having to pay.
without you having to pay. Yes, there are special provisions to for British nationals to be repatriated back to the UK. So you could be abandoned, maybe you're the victim of a crime, your partner, abusive partner may have abandoned you in a country, taken your wallet, you have no money. There are ways for you to make representations to the embassy to get you back. Then do go back to what I said earlier about the fee waiver applications. Very important. This is an underutilized provision by the Home Office. It does require you showing evidence of your income and expenditure. It does require you showing whether you're at risk of homelessness. So it's better you ask and not get than not ask at all and suffer. So please try and do it. There are certain agencies and NGOs out there that can help, but we're also here really willing and able to help. We have our free clinic every Friday, and we're happy for anybody who comes in that has needs with regards to fee waivers or wants more information or how to do it, to come in and just get the help that you need. And so you don't need to suffer in silence. Ask and let us help you.
Please do not suffer in silence. Ask and let us help you. Thank you so very much. We've come to the end of today's show. We'll come your way again next week. But before then, email us, give us a call. Go on Facebook. Our page is Truth and Justice TV on Facebook page. Share our page, like it. Send us a text. If you want us to do home visit, we'll come your way.
Yes.
Absolutely.
As
Just
part
get
of
in
the
touch.
victims of Windrush, we went out and saw so many people who are affected by Windrush.
Yeah.
This is because they were elderly or they couldn't come to the office.
Exactly.
We've also been out to see people who have concerns, elderly people who have concerns about their young relatives in Nigeria and how best to help them do visitors visas. So again, whatever the need is, call.
We are here to help. We are here to help. And if you're willing to talk more and you want to actually share your story on this case of migration, we'll be at the House of Commons on the 12th of September 2018. Log on to Truth and Justice TV on Facebook, our page. The link to register to attend is free, but the link to register to attend the event is there. It will be good to see you one-on-one, and then we can actually discuss and help you solve your immigration problem. We are actually here to help. Till we see you, same time, same station, next week. Be good.
Be
See you
good.
next
If you
week,
can't
Monday.
be good, be careful.
Be good. If you can't be good, be careful. We'll see you next week.
Stay
Good
blessed.
night. Bye.
Bye-bye.
Bye.
When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. OBASEKI Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020-7739-7549 or go online at www.legalpal.com.